Welcome to Arbitration Acumen, a podcast from Bracewell's International Arbitration Group that connects in-house counsel and arbitration practitioners with industry experts, institutional insiders, and top arbitrators from around the globe to share their views on key issues in arbitration today. You can reach out to any of today's speakers by emailing arbitrationacumen@bracewell.com. And we hope you enjoy this episode of Arbitration Acumen.
Welcome back to the next episode of Arbitration Acumen, in which we'll discuss the Mumbai Centre for International Arbitration, colloquially known as the MCIA, with Neeti Sachdeva, who's been the MCIA's Registrar and Secretary General since its inception. I'm JP Duffy. I'm an international arbitration partner at Bracewell based in New York that acts as both counsel and arbitrator in international arbitrations seated around the world under a variety of governing laws and arbitral rules. I've been working on arbitrations that have an Indian connection for over 20 years, with my first, and I know Neeti's going to appreciate this, being seated in Bhubaneswar and Orissa in 2002. I'm qualified in New York, England, and Wales, and the DIFC courts in Dubai, where I previously practiced. As I mentioned before, our guest today is Neeti Sachdeva. Neeti is the MCIA's Registrar and Secretary General, as I said, having joined in 2016 from private practice at well-known Indian law firms. Before that, Neeti was the first Deputy Registrar for LCIA India. She worked in the International Arbitration Group in Paris at a well-known international law firm. She was a judicial law clerk for Justice Geeta Mittal and Muralidhar of the Delhi High Court. Neeti has a master's degree in international commercial arbitration from Stockholm University. She's undertaken a course in private international law from the Hague Academy of International Law in The Hague, and somehow still finds time to sit as an arbitrator. She's got quite a resume and quite a CV, so we're very fortunate to have her today. As you can tell, Neeti's got a wealth of knowledge about the MCIA that she can offer, and with it approaching its 10-year anniversary, it's a great time to speak with her. So before we hear from Neeti, I just want to give some brief background information about the MCIA for those audience members around the globe who are less familiar with it and the incredible growth of arbitration in India generally. The MCIA was established in 2016 as an independent, not-for-profit arbitral institution that's a joint initiative of India's domestic and international business and legal communities to provide world-class dispute resolution services in India. In addition to the day-to-day work that Neeti does as the Registrar and Secretary General, the MCIA is overseen by a body called the MCIA Council, which is comprised of renowned Indian and international arbitration practitioners that bring a wealth of experience to the MCIA itself. One of the MCIA's primary functions is to provide an efficient and cost-effective alternative in India to ad hoc arbitration, which was, for a lot of years, the default arbitration process in India. And I should mention, I've dealt with that quite a bit, and I've seen over the years the initiatives to sort of move towards more administered arbitration. And I think the MCIA really has been integral in accomplishing that. I also want to share a few interesting statistics about the MCIA that show how effective it's been in accomplishing its mission over the last 9 years before we hear from Neeti. First, in 2024, the MCIA managed to have 91% of its cases completed within the 18-month time frame required by the Indian Arbitration and Conciliation Act. That is quite an accomplishment for anyone who's ever done an arbitration that involves India. Second, none of the awards issued under the MCIA rules in 2024 that were judicially challenged were vacated, which is itself quite an accomplishment as well. And the DIFC courts in Dubai in 2024 even enforced an MCIA award for the first time. So the MCIA has been extremely effective at ensuring that its matters result in enforceable awards. Now, lastly, the MCIA Secretariat has excellent reach within India and maintains offices in 3 key commercial locations: Mumbai, Bengaluru, and Delhi. So it's got reach across the entire country. So as you can see, the MCIA has accomplished quite a bit in less than its first decade, slightly less than its first decade. And it occupies a unique position amongst arbitral institutions in India. So we're really, really fortunate to have Neeti here to talk to us about that. So Without further ado, let's turn to Neeti so that you're hearing from her directly. Neeti, welcome, and thank you for joining us today.
Thank you so much, JP. It's such a pleasure to be here. And while you were narrating all the statistics and what MCI has done in 9 years, it did feel that we have been able to achieve some bit of what I started my journey and wanting to do things with the MCIA. Yes. So thank you for having us.
Wonderful. Well, let's talk a bit then about how many cases the MCIA has administered since its inception in 2016. How many is that?
So, JP, before I give you the statistics, I think I just wanted to tell you one thing that, when we started with the MCIA, and for the people who may have some experience in the Indian market, they would realize that there have been many arbitral institutions in India, some successful, some not so successful. But one thing that we wanted to stand out ourselves was that every year, whether we had one matter or whether we had 34 new matters, we wanted to publish a report so that people can have some confidence, go back and look at the statistics and say that this is what the institution has done. So if you look at published statistics, the last report that we published was of 2024, which we published in January. By then, we had received 117 new matters. This year, we have already received, actually, I would say we've received a little more than 30, but we already have an active 30 matters we've received this year. So it'll be 117 plus 30 matters. That's what I would put.
Excellent. And that's a pretty significant increase over 2023, correct?
Yes. Yes. Last year was very good for us. As in last 2023, 2024 was a good growth. And I think we're seeing touchwood this year to have a good increase as well. Last year, we saw about a 48% increase in our caseload.
Wow, that's a very significant increase. Now, how many of those cases were international?
We had 6 cases actually, which involved international party. So again, just to give a context to it, JP, in India, as you mentioned, and with your own experience as well, that predominantly we have ad hoc arbitration, which still remains the norm as to how the arbitrations are done in India. So one of the low-hanging fruits for us has always been, and what we want to change with the MCIA is the Indian market and how domestic arbitrations really work. So a lot of our focus has really been on popularizing and making the Indian conglomerates realize the importance of administered arbitration rather than the ad hoc arbitration. But having said that, what we are now seeing is that progressively more and more international parties are finding their comfort that if it's an India-related party, one party is an Indian, another is an international, we are seeing more and more adoption of the MCIA clauses. But till now, I would say about 18% of our caseload is about international.
Wow, that's a very significant increase. And I just want to pick that up for a moment, the effort in India to have more institutionally administered arbitration, because it is a tradition of ad hoc. And I have certainly heard over the years, over the last 15 years, the Indian Council on Arbitration, the Indian Supreme Court, everyone pushing hard to have more administered arbitration. And obviously the MCIA occupies a really unique position in helping accomplish that. It is something that oftentimes people perceive ad hoc arbitration, that is, to be quicker and cheaper and easier. I think the reality is that it is oftentimes not. It's oftentimes much more expensive. It's oftentimes much more complicated. You end up having to resort to the courts a lot more. So, when Neeti pushes hard to have domestic arbitration as well institutionalized, that's a really important initiative because it really helps develop an efficient, strong process, which is something that MCIA is clearly designed to do. Now, with that, Neeti, let me just ask a quick question. How many cases then that the MCIA is administering come from court referrals?
JP, I'm sorry that every question that you ask me, I give you a background before I give an answer, because I think it actually...
No, that's good. That's good. Go ahead. That's what we want.
Because I think I want to put it in a context, right, as to where it comes from. So if you look at MCIA, when you were introducing it to our audience today, one of the first things you said was that we're a not-for-profit private organization. So if you look at MCIA, we are very unique in how we establish, because we neither established by a government, nor by a court, and neither by any chamber of commerce. So we're completely, purely neutral in that sense. In India, we've had arbitration institutions which have been linked to high courts, And that what has happened is that the ad hoc matters which go to a court for an appointment of an arbitrator then sees themselves going to these court-annexed arbitral institutions, which I would say being in Mumbai doesn't have any court-annexed arbitration center. And when I joined MCIA from its very beginning, we thought it'll be a great opportunity. We'll get the courts to refer the matters to us. But I think which was also a unique position that we were purely neutral was also at times, took time for the courts to realize that how authentic we were. And what is it really that MCIA would want to do? Our first matter, in fact, is what came from the court. So the Supreme Court of India in an international commercial arbitration involving one Indian party and one Nigerian party. And the Indian party had approached the court because the seat was India to appoint an arbitrator. And the court referred the matter to MCIA and said that we will let MCIA appoint and administer the matter. I think that was a very big sense of, confidence building for us and what the courts reposed trust in us. Since then, we saw that we had more matters referred to us from the Supreme Court, which is the highest court of India, and only international commercial matters go to them. Every year on year, we've got matters referred by the court from different judges, even the Chief Justices of India, but which was still a very marginal number. I would say that only 15 matters since inception, so approximately about 13%. This year, I must say, I do not know if I'm spilling the beans too soon because we usually publish all these statistics in the January. So you're hearing a lot of me of what's happened in the 6 months already, which a lot of people may not know. This year has been particularly important for us because we've had the Bombay High Court refer matters to us, and we've already got 12 matters which are active and they have been referred by the Bombay High Court. So we're now seeing a lot more court reposing trust in MCIA, which I think is a great thing to see in India.
Wow, that's really impressive. Let me just make sure I've understood that. So in the time since inception, there's been 15 cases referred, but you've had 12 referred this year from the Bombay High Court alone, and it's only 6 months into the year. Is that?
That's right.
Wow.
And my fingers are crossed that we should get more.
All right, listeners, perk up. You just got some great inside information about the MCIA right there. Well, that's a really important source of cases then. But I also think what's great about that is obviously parties themselves are reposing trust in the MCIA as well, if such a small percentage of cases over the years have been referred by the court. So that's a really nice development on two fronts. Now, Neeti, just in that regard, how much time do you spend working with the courts to develop that trust that you described and to develop that relationship that's so important?
A lot, I would say. I mean, see, one thing is to get the matters referred to MCI, right, JP, which is, of course, what we want to do. But I think another very important factor for us is that when any matter gets challenged in an Indian court, we would want the courts to have the faith that the process and the procedure has been followed and there has been an independent organization overlooking the entire process, right? I mean, India is a big country, as everybody knows. Unfortunately, you wouldn't have the same sort of judicial, I would say, commercial acumen. I mean, our judges are great, but not every court in India probably does commercial matters in the same numbers. But, awards can get challenged anywhere. So some of our efforts, especially when we do events in India and like we do the India ADR week, I know there are enough arbitration weeks. Some of us can just do a job attending them. And India has its arbitration week as well. I think the only difference is that in the entire week, we are in 3 different jurisdictions. So Monday in Bangalore, then 2 days, Tuesday and Wednesday in Mumbai, and Thursday, Friday in Delhi. And then we also do our annual event in Ahmedabad, which is in Gujarat. And through these events is where we engage with the courts and the sitting judges to tell them what's the statistics, what's the sort of a support we have from the practitioners and, even from the in-house counsel. And just to give you an example, JP, how we see that helps is, we had an emergency arbitration matter, which was referred to MCIA. This was from a contract. And again, for our listeners, in our Indian Arbitration and Conciliation Act, we still do not have a provision for emergency arbitration, though our judicial pronouncements have recognized emergency arbitrator's order. Now, this was a purely MCIA emergency arbitration order, and it was challenged in a district court of Ahmedabad. And when I specify or I put emphasis on district court, I say it because the district courts do not see that many commercial matters, arbitration matters going to them. And if you look at the order, which is of course recorded and is available online, the court has specifically, put it in there to say that it is an MCIA administered order as an arbitration, and the arbitrator appointed is of an impeccable integrity. We see no reason to interfere with it. I think that's the sort that when you engage with judiciary and they know that what's a process that you have followed, there's a faith and trust built in from there as well.
That's really impressive. And I can say from the amount of time I've spent working on India-related arbitrations over the course of my career, that is a groundswell shift. Because 15 or 20 years ago, that might well have been the exact opposite outcome, right? A court saying, well, we are going to step in and take control of this, but ceding that entirely to the MCIA because of its trust in the organization is really impressive. So obviously have done a great job developing that trust.
Yeah, I mean, we have been disrupting the market quite a bit, I must say, JP, since you have an experience and you've been in Bhubaneswar, as you said, you would also realize that in India, a lot of people say that, it's the retired judges who are always appointed as arbitrator. While we have the utmost respect for them and we do see parties appointing them as well, but in MCIA, we have a very distinct rule, which is that the presiding arbitrator is always appointed by the MCIA. That was very carefully thought after when we drafted this because, we sort of, how do we change the market? And how do we bring in the international best practices? So one of the way we thought was that if we have the presiding arbitrator appointed by MCIA, we can bring in those people who have an experience in the Indian market, have an experience in international commercial arbitration, and to be leading the procedure. And you'll be surprised, JP, that we have had matters. We've had 2 retired senior judges of senior courts, and we've appointed somebody who's junior in terms of the number of years at the bar, but enough experience internationally, and they have just welcomed that step as well. Right? So that's the shift that we are looking at in India in terms of how things are happening.
Wow, that's a really important development. And, it's funny, I was speaking at a FICCI conference probably a decade ago when the law minister came out and said very clearly to the audience that, it was really important for India to develop its own specific arbitration bar, right? So to sort of move away from the practice of having people that dabble in arbitration or that spend less time working on arbitration. And that's not a criticism. I think it was just a reality of how the market developed. So to hear that MCI is furthering that is really important because that does materially increase confidence in the process, not just in India, but around the globe as well. And that will certainly help India move towards becoming a global seat for arbitration too, which is another important objective that I know has been really, really, really sought after. So great to hear. Neeti, just before I lose the thread, let me ask a quick question. What countries were the top 5 users of MCIA in 2024?
We had matters involving China and Germany that I would say were the top 2 that we saw. Like I said, most of them were Indian matters. So I wouldn't say that there were 5 international jurisdictions involved in the matter, but we also had very strangely one from British Virgin Islands as well. So I would say those are the top 3 that we saw in terms of the parties involved in the foreign jurisdictions.
Okay, wow. And certainly China makes a lot of sense to me. BVI does make sense too because of the probably investment structures. And very interesting about Germany as well. That's really impressive. Now, how has that changed over time? Have you seen any sort of shift in foreign users or anything of that nature?
I mean, it's strange that if you look at our reports over the years, I mean, we are also a new institution, right? So our data is that sense a little smaller to give a proper analysis of it. But if you look at a previous year, that year we had matters with parties involving United Kingdom and United States as well. China is something that we have seen sort of matter coming in. A year before, we had, parties again involving United Kingdom, United States of America, Singapore as well. Then we also had matters from Abu Dhabi and Cyprus. Germany again was there in for the year that we submitted a report 2 years back. We still saw Germany there. So I think we sort of see Germany and China being a little more constant. London once or twice that we have seen the matters as well.
Okay, well, that's a very interesting development. Let me then just shift for a moment because I don't want to lose sight of the fact that on May 1, the CIA had new rules take effect. And that's the third edition of the rules, correct?
That's right. I mean, we would say effectively second, because when we released our rules initially, the second edition was just really a change in our fee structure to align it more to the Indian market, we realized. So we didn't really make any change to our substantive rules. So that's why, in effect, I could say that in terms of the rules, it's second edition, but we do call it a third edition for the reason because we did change in between the fee structure. That's why.
Okay. Well, that's good. That's good. Yeah. And the fee structure is obviously important too, to encourage people to use administered arbitration over ad hoc. So obviously an important development there. But let's talk for a moment about those new rules. What are some of the salient features of those new rules? Like what are things that you'd like to point out to the audience about those rules?
I would say first is really the joinder provision. So when we launched our rules 8 years back, there was a discussion that we had whether we should have a provision for joinder of non-parties or not. And we decided not to include a provision at that time because I think the law in India was still not as developed. And this time when we were, looking at the rules again, the revision committee which started to work, I think we had a consensus again that now the time had come for us to include a provision for joinder because we've had some very good judgments as well from the Supreme Court, supporting the group of companies doctrine as well. So we thought that was important for us. And that's why we have a new provision altogether on the joinder. Similarly, on a consolidation, we did have a provision, but we have sort of now expanded its application. Other important, I would say, provision for us is on the early dismissal and summary procedure. So the Indian Arbitration Act talks about a fast track procedure. And we thought that we should have something to talk about early dismissal, which we didn't really see much in the Indian arbitration context. So we sort of wanted to introduce a new provision and see that if Indian parties find a more value to using something of this sort to make their arbitrations more, efficient, cost effective, timely and stuff like that. That's been the major focus for us to make sure how our rules can make sure that the arbitrations are done even in a more quicker format, but of course, giving the parties enough opportunity to present their case. The other two things that I want to highlight in our rules is a provision on TPF, third-party funding. The Indian law does not have provision on third-party funding yet. So unlike some jurisdictions who have now adopted, the new rules and acts, we still haven't done it. So I think this was a sort of a bold step for us to add that as well. Just like in our first edition, we did the emergency arbitration, and that's been pretty successful. We've had about 5 cases used till now under the emergency provision. So this was another of an addition of ours to bring something more codified, if I may say, in terms of our rules on third-party funding. The second one I would talk about is on the tribunal secretary. So MCIA has been conducting a course on tribunal secretary now for last 2 years, which is followed by an examination. It's a proper examination, and only people who qualify the exam are then, so we put them the details on our website to say that they are tribunal secretaries, qualified. Again, the reason, JP, is that everybody in international conferences, you go, podcasts like this as well, talk about that we need to have a larger pool of arbitrators. But then how do we create this pool, right? And we thought that having these tribunal secretaries, training them, and then attaching them to the arbitrations is a good segue for them to then start accepting arbitrator appointments. The last one that I will talk about, an amendment to our rules, which particularly I'm a big fan of, is the publication of awards. And this was, again, to bring in more transparency, right? Of course, we want to maintain the confidentiality. If parties would not want their award to be published, we do respect that as well. But otherwise, now we have a provision to say that MCIA will redact the awards and publish them. And in fact, to that effect, we have entered into an MOU with Jus Mundi as well.
That's really interesting. And I just want to pick up on 2 points there. I think first, the tribunal secretary point is a really important one. That it's really important that younger practitioners get a lot of experience so that they can sit as arbitrators and so that they really do understand the process. And that really will help develop an independent arbitration bar to the extent that one still needs development. I mean, that really important development there. The other is the publication of awards. I agree. That is something that is really interesting to me because I sit on the publication committee of a U.S. arbitral administrator, and we work with Jus Mundi too. That process is really important. And I had that highlighted for me last year at an event I was hosting with a Second Circuit judge here in the U.S., a federal judge here in the U.S., an appellate judge who was talking to me ahead of time and said, one of my major concerns is that we don't see as many commercial cases here in the Second Circuit anymore because a lot of them end up in arbitration. And I was very surprised to hear that because New York is such a large jurisdiction. And the publication of awards was really his concern because he was saying, look, so much of this commercial law now is developed privately in arbitration that I wonder how well it's going to be published, here in New York. And so the publication of awards is a really important development. And it's a challenge because, working with Jus Mundi, they're great, but how you redact those awards, how you get them in the public domain while preserving confidentiality, which is obviously something important under Article 46 of the MCIA rules is a challenge, but good to hear that it's a challenge you're taking on. Now, let me just ask you two quick questions before we move on, Neeti, because this is really important. Emergency arbitration under Article 19, if you could just give the audience a very quick overview of the timeframes and the deadlines in that, I think that would be helpful. And then I want to just ask you quickly about Article 17, but let's start with emergency arbitration for the moment.
So the emergency arbitration, once we receive the matter, we have to appoint an arbitrator in less than 48 hours. I would say, we just have, like I said, about 5 matters that we've done till now. We've been able to appoint an arbitrator in less than 24 hours. The second timer that we have is to get to the order itself, where we have a target of about 14 days. And again, we have seen that on an average, we've been able to get an order from the emergency arbitrator in about 9 or 10 days. So till now, fingers crossed, things have been good.
That's impressive. And that is definitely, again, a pretty important shift. Then let me ask you just quickly about expedited arbitration, which you touched upon. What are under Article 17? What are the monetary thresholds and what are the timeframes there?
So for expedited procedure, we have now increased it under these rules. Now it's about approximately 1.5 million USD. So if your dispute is up to that amount, you could go for an expedited procedure. The timelines are reduced to about 6 months to get your award. And we also encourage that the parties go only for a documents-only arbitration. In fact, JP, we are now using that provision a lot. I would say in this year, we're using it a lot because the matters which have come from the Bombay High Court, like I mentioned to you, some of them are not really very high value cases. And we, sort of brought it to the notice of the parties that, the matter may have been referred from the court, or we do have a provision for expedited where you'll have only a sole arbitrator. You could do it only documents only and, in a reduced time frame. And in fact, in more than half of the matters, I would say parties are happy to do it.
That's great. And it's amazing to me when you look at some of the statistics around the world of what percentage of administered cases are sort of smaller value. So really good that recognition has been there. Okay, well, we have so much we could talk about, and there are so many things going on that we could probably speak all day. But I think what's going to make the most sense is to have Neeti back, because there are obviously a lot of stats that are going to be relevant in early 2026 as well that she'll be able to talk about. So let's move on just quickly to looking ahead, because this is something that is clearly in your purview. With the MCIA approaching its 10-year anniversary, it's a natural time to reflect on past accomplishments and look at what you want to be doing in the future. So, Neeti, what are some of the things that MCIA has accomplished so far about which you're most proud, keeping in mind that you've been there literally since the inception?
2 things I would say. One, I would say the trust of the courts. So I can tell you this, JP, that when we got our first matter and it got from Supreme Court, I can't tell you how happy we were. Because as you rightly said, unfortunately, our courts have always been criticized to sort of keep things to themselves and not have that trust. So, it was an arduous journey when we decided that we do not want the funding of the government, or we do not want to be under the Chamber of Commerce, or to be supported by a court in terms of under its aegis, and to be private institution. I would say that was a real moment which gave me sort of encouragement that we can do something with MCIA. and we're on the right path. I think the second one has been that on our arbitrator appointments, we have been pushing as an institution, and I must congratulate my MCIA council as well, that they've been very supportive. We do appoint women as arbitrator. We are conscious of that. Also, people to have their first appointment as an arbitrator from the MCIA. There are people who have done in India great practice over the last 15, 20 years as being counsel, would have done about hundreds of matters, but probably never taken that step to go from a counsel to an arbitrator practice. And when we have, spoken to them and said that would they consider doing something like this, they said, oh, we never thought of it. But yes, why not? And they have been fabulous arbitrators. And that sort of, I think, has built up the confidence of the practitioners as well. So I think I'm very proud, I can say that, as humble as I can be, to say that the court support, of course, the support of the practitioners has been there, the users has been there. But I think the second thing that we've been able to achieve in a very, I would say, a market which would not see beyond a certain pool of arbitrators, to be able to appoint women and to be able to appoint people to get their first appointment under the MCIA.
Both really, really important developments and really important accomplishments. So great to hear. With that, what would you like to see the MCIA accomplish for the remainder of 2025? It's obviously been a pretty active first 6 months. So what would you like to see? How would you like to see it close out 2025?
Wow. I mean, it's my wish list really, right? I mean, I wish I had a magic wand. I could convert all the ad hoc arbitrations to an institutional. I wouldn't say an MCIA arbitration. All ad hoc arbitrations to be converted to institutional arbitration, and all institutions coming together to administer that. I think that would be my wish list. But more realistically, I think it's about our timelines. It's always good to have a great numbers and to come to, podcast and talk about that we've got 20 matters, we've got 30 matters. But I think as an institution, it is important that we don't do a time overrun. And I think for us, that is what we want to keep achieving, that we want to finish our arbitrations in 18 months' time. And that's what I probably look at.
You've obviously accomplished that so far. Now,
yes.
With that, where would you like to see the MCIA in, say, 5 years?
Me retired.
Well, if all those ad hoc cases convert to MCIA, you're going to have to retire because you'll be exhausted.
I would say that where I see MCIA in 5 years is to be a natural choice for Indian parties, to be doing it for domestic, of course, to be using it for domestic arbitration, but for the international parties to have the confidence that they can choose MCIA even in non-Indian related disputes.
Excellent. Well, obviously that's starting to get there. Well, that's great. Well, this has been such a wonderful conversation, and we did not get to discuss everything I would love to, including digging into some of the arbitrator appointments and all those other things that we started to touch upon. So I think what we'll have to do is we're going to have you come back in 2026 to discuss how 2025 concluded and touch upon some of those other things that we didn't get to. But I think we'll have to save that for another time. So with that, we'll wrap up our discussion of the MCIA. I want to thank our guest, Neeti Sachdeva, for her time and invaluable insights. And I want to thank you, the audience, for listening today. You should feel free to reach out about today's podcast with any questions you might have to either Neeti or myself. And we look forward to having you tune in for future episodes in the Arbitration Acumen series. So thank you, Neeti, again. Such a pleasure. And we look forward to having you back in early 2026.
Thank you so much, JP. It's really wonderful to be here. And I get a bit more passionate talking about the statistics of MCIA. But, before we conclude, I must tell you this, that today anyways is a very, very important day. Because in India, today is when we celebrate to dedicate, to honor and express a gratitude to our teachers and mentors. It's a very important day. So I think for me, it's very important to thank my, mentors in the field of arbitration as well, who have encouraged me to be able to do with MCI what we have been able to do. So thank you so much for recording this on such an important day for me.
Oh, that's lovely. What a great way to wrap this up. That's a really fantastic thing. Well, thank you so much. And it's really wonderful to see the MCIA doing so well and you doing so well. And we look forward to hearing all about it in the future.
Thank you and bye-bye.
Thank you for listening to this episode of Arbitration Acumen. We hope you found it insightful and informative, and we encourage you to share it with your colleagues if you did. You can reach out to any of our speakers by contacting them directly or by emailing arbitrationacumen@bracewell.com. We welcome any questions or suggestions you might have for future episodes. And please subscribe to our podcast channel to stay up to date with our latest content.